one of the sessions of the first Arbitration Week. Congratulations to Diana and the organizing committee for putting together so many remarkable events.
Такое количество экспертов.
Paris Sherman Sterling, and I will moderate today's discussion on the clash of culture in international arbitration. We are going to cover this topic from different perspectives, and we also going to discuss not only the legal aspects of clash of cultures, but also some cultural differences and how arbitration practitioners are dealing with them. We have several speakers today, and I would like to say a couple of words about each of them. I'll also be, I don't know whether we will have, just 1 second. Just whether there is an option for questions from the audience, but if there is, we will answer during the discussion, or we will have some time at the end of the discussion. Unfortunately, Dr. Lihu was not able to join our panel today, so it's just 5 of us. With us today, Chris Campbell-Holt, who is a register and chief executive at the Astana International Financial Center, International Arbitration Center. Our next speaker is Konstantin Kroll, a partner from Dentons. I think he's joining us from Moscow. Then we are honored to have with us today Dr. Serhat Eskiyuruk, who is the General Secretary at the Energy Arbitration Center. And last but not least, Ignacio Torsterello, partner at the GST-LP from Washington. International arbitration is a perfect example of how different cultures can mutually benefit each other and contribute to the development of legal system in general. In arbitration, clash of cultures is usually invoked as to mean a clash of two legal families represented by civil and common law countries. Did arbitration lead to harmonization? Let's take, for example, the IBA rules on taking of evidence in the trial modern law, and we see how they were able to accommodate different perspectives in arbitration. But is there a consensus, or just there is a compromise in international arbitration? And we, as arbitration practitioners, we dealing with different wars, even in different languages, almost on daily basis. And for us, clash of culture is not only about legal clash of culture, but it's also sometimes just some different cultural backgrounds. And I would like to start our conversation with our panelists sharing example of them dealing with different cultural differences, but not legal. Chris, would you like to start?
Thank you. I'm not an expert on the IBA rules. If you'd like to pass that to someone else.
So the question not about IBA rules, but about cultural differences. If
Right,
in
okay.
your experience you have dealt, yeah.
All
For
right, thank you
example,
very
like
much.
in France, okay.
I can certainly answer the question from my perspective. I should say, if it's helpful to everyone, I can't really hear you very well. There appears to be some constant cutting out of the Wi-Fi. I hope it's not from my end, but if it is, please let me know. In any event, I'll do my best to answer the question. So very briefly, from my perspective, I worked for many years in London, and then in 2010 moved to Qatar in the Middle East, where we set up a similar center for common law court litigation, but also for arbitration and mediation. And for the last 4 or 5 years, I've been in Kazakhstan at the Astana International Financial Center, where we set up an international arbitration center. There's And firstly, I should have said from the outset, congratulations to the organisers of this excellent event, and join you in what you said, Anna, in that regard, in particular to Diana, who's in charge of the Tashkent International Arbitration Centre. At our arbitration centre, we have for some time now enjoyed an excellent cooperative relationship in various ways, and we look forward to continuing that for the foreseeable future. Back to the question. One example really is in Qatar, where a classic really was during Ramadan. For whatever reason, we had a hearing, arbitration hearing during that period. A practical matter was that it was not permitted for anyone to be drinking water or to be seen to be drinking water or eating any food. There was a very strict policy at that time throughout Doha, the capital city of Qatar. And of course, we had to and did respect that. For some parties, the lawyers and for the arbitrators, that caused some discomfort. I mean, it's not easy to talk, perhaps not necessarily on your feet in arbitration. We tend to sit down more than stand sometimes, but it was quite difficult, in fact, very difficult for the lawyers in particular and the arbitrators, because talking for 6 hours or so, as it was, is not particularly easy in a hot climate with no water. So these are very, might seem from the outset, extremely basic matters, but they are real, and that is not the only example of that I can think of from my experience. There are ways around managing that, but in this particular instance, it was not possible given the requirements of the case. Dispute resolution. In Kazakhstan, and we could talk for hours about this topic with lots of different examples, but a very quick one from Kazakhstan, in my experience that I've seen, is the presence of mind. There is very much here a determination or expectation, if you like, in the minds of people, business people that I've come across in Kazakhstan, that everything will be done extremely quickly. It's not good enough to have an arbitration that might take 6 months. Everyone wants it now. You appoint the arbitrator, chairman of our centre, or the parties appoint the arbitrator, and they expect the decision the next day, or the next week, or 2 weeks later. And that, as a matter of practical reality, I'm sure we'll all agree, is simply not possible, and I would say, not appropriate in many cases. There tends sometimes to be in the minds of people too much focus on speed and cost, which of course we all focus on to be as efficient in terms of cost and speed as we can. But we do of course need proper exploration of facts, laws, and proper consideration of the evidence by the arbitrators in order for them to be comfortable with coming to what they determine is justice in the case. So that is excuse me, a practical problem in the minds of some people that we see on a daily basis now in our arbitration centre.
Thank you, Chris. So practical advice for our practitioners who are envisaged to attend hearings in a Muslim country, in some of the Muslim countries, it can be just to check how it's happening during Ramadan, or maybe to calculate and not to schedule hearing during Ramadan. Konstantin, what you would like to share with us?
Thank you, Anna. I'll start by greeting our audience and colleagues on this panel, and thank you, the organizers. I'm delighted to take part in this discussion, and indeed the Uzbek Arbitration Week. On the sort of clash of cultures, I'll start by saying that culture is connected to and part of the language. So one cannot exist without the other. And indeed, the arbitration proceedings, they take place in certain language that was chosen by the parties. And in international arbitration, it is very often English, which may not be the native language of the parties to the proceedings and the advocates representing the parties. And the thing about English is that one may be fluent in the language, yet if you're not a native speaker, you may miss certain cultural references. And even if you are a native speaker, there are different versions of English in Great Britain, in the United States, and elsewhere in the world. This is really relevant to how parties present their case and whether they understand each other and whether the arbitrators read what the parties are saying the same way the parties are sort of putting the meaning into it. Well, I'll give you a few examples. In the Russian context, for example, if someone says that they're really interested with what the other party is saying, that's what it means. In the London or English context, if you present a case and the other party listens and says, yes, I hear what you're saying, this sounds interesting, that means that you are talking rubbish and they're not particularly in agreement with you. I'll give you another example. If an English or British person says that this is quite good, for an American, for example, this may not sound very strong, because an American would say, well, this is excellent, this is really great. So the British have a way of understating. So when a British person says this is quite good, this means this is excellent. For someone who is not familiar with the British ways, this is a weak statement. And this list may go on and continue. So the importance is really to appreciate these cultural differences and be mindful of the importance and effect of the language and what it really means. And maybe another practical tip to a party, in particular for witnesses, don't overestimate your command of foreign language. And it is a good practice and prudent advice to rely on professional interpretation. Because even if you speak the language, if you speak in your native language and rely on a professional translator, that gives you an extra time to digest questions and digest the strategy while the interpreter is interpreting. Because there is a risk that you may misstate something, or a native speaker would get you in a different way, not the way you meant. So that is sort of my piece of advice. Thank you, colleagues.
Thank you, Konstantin. That's true that while considering what language to testify, it's very important to strategize and to understand whether the witness, and especially expert witness at the moment of stress, is sometimes and always it's very stressful, and sometimes people even can forget words in their native language. Or when you work in different languages, and it's always a mix of all languages, especially in arbitration. Ignacio, what about you?
Well, thank you very much. Good morning to everyone. It's a great pleasure to participate in this panel. It's a pleasure to get to know my colleague panelists. And I also join all of them in saying thank you to TIAG for the fantastic organization of this Uzbek arbitration week, which has been so far great. First of all, I wanted to say that this is a very interesting topic to discuss, and I think especially for the young practitioners in Uzbekistan that are attending, it's something to take into consideration. I fully agree with my colleague panelists on their statements before, and because the chair requested us to think about examples from not the legal life, and I wanted to bring something from outside the legal life. Yesterday, I'm here in Uzbekistan with one of my partners, Domenico Di Pietro, and we were having this conversation about the panel today, and he mentioned a case that I'm sure Konstantin will appreciate, which was an Italy-Germany match, football match. And he was telling me that there was this Italian with a banner in which it says, please don't cut the spaghetti. And definitely this is kind of a different appreciation to the same thing. And I have personally lived in Italy for 2 years. I'm originally from Argentina, and when I got to Italy, I had this custom to cut the spaghettis, and my colleagues in Italy were horrified when they saw me cutting the spaghetti. And these are the kind of things, and we live that those experiences every day in international arbitration, and we have to be very careful because especially the panel of arbitrators can misinterpret what we are trying to convey when we are not using the correct forms and the correct words.
Thank you, Ignacio. My former colleague, who is Italian, he was always shocked when I wanted to drink cappuccino in the afternoon, because in Italy it's like a crime to drink cappuccino in the afternoon, and some even restaurants refuse to serve cappuccino. So hard.
Yeah. Something else is going to put Parmesan cheese on a sauce. They will refuse to sell.
And hello, thank you very much for Tiak for this great event, and thank you very much for asking for my opinion. I am a Turkish origin, and I studied in London and was a visiting academic in US and in Germany. I had some different perspectives, but still, I mean, it's not an easy issue to recover all different legal systems, all seats, different languages, different cultural, regional differences, diversity of rules. Even as you mentioned, Anna, there's a harmonization in trend for arbitration, but there are huge gaps sometimes. And even I should say, as a Honorary Secretary General of EDAC, Energy Dispute Arbitration Center, as I also see the differences between different sectors like maritime, energy, finance, or sports. Different kinds of disputes has different trends and views. But of course, our perspective is mainly between civil and common law perspective. So I think we will discuss in a further, but as we see from the applicable law to the seats, to the rules, it makes difference. It's really, the parties should make different expectations when they choose an English law or an Uzbekistan law. And also different, as Chris mentioned, like different procedure like IBA rules or CRAC rules, or the US core system on discovery. Well, there are lots of differences, and I'm really excited to discuss and to be in this session. Thank you.
Thank you, Serhat. I believe that you spent a couple of years studying abroad. Maybe there is any example that for you it was a cultural clash, a cultural shock, or something that you might remember?
Yes, I mean, even to get the treat, I mean, it makes difference. Even the way you sit in a coach makes difference. I mean, maybe in an American way, to sit in a way very relaxed should be accepted as a not respectful in a East culture, for example. And also making your voice very high, for example, may be very normal in the US, but it may not be very welcoming in Asia. I know you, maybe Chris might have some more from English perspective and more Uzbekistan and Qatar perspective. And I'm also Muslim origin. I try to adapt when I look at the other people. In Turkey, we are between East and West. There's we believe in like a bridge, and try to understand both cultures. But of course, always you should teach your lesson and get ready, and you should try to learn the cultures before getting to in a meeting at least. Thank you.
Thank you, Serhat. And I believe we have the first question from the audience. Do speakers have any thoughts in connection to body language differences attributable to different cultures and how it might impact the proceedings? Who would like to take this question? Chris?
Thank you, Anna. Thank you for the question. I would agree with everything, of course, that all of our distinguished panel members have said. And body language, a classic in the Middle East, is shaking hands with women. It typically is not permitted. One goes to the Middle East perhaps for the first time if you do, although that's less common now because the Middle East is very well regarded for business and legal systems and dispute resolution and holidays and all the rest of it. So we're all more than familiar now with the Middle East perhaps at an international level than perhaps we ever have been before. So I would hope that people's expectations of different cultures would be better informed than perhaps 15, 20 years ago. But in any event, you will find sometimes, in my experience of 7 years living in Qatar, the Middle East, that some women will be very happy to shake a hand and indeed will offer it, and others will not. But if you get it wrong, you can cause significant offence, not only to the person, but sometimes to the people in the room and the family members that may or may not be associated with that person in the time, place, or whatever. So there are all sorts of things which need to be very carefully considered. I'm not aware of any expert course that anyone can attend on world cultural challenges. They must be out there, and forgive my ignorance if I've got that wrong, but that's not something that will perhaps be in the utmost of importance in the mind of a very busy senior lawyer who has to run around to different countries at different times, fighting battles, often under great pressure. So the other point I wanted to make very quickly, if I may, is we're looking, of course, at international arbitration, but clash of cultures, put it into a bigger perspective, it appears everywhere. Mankind has always had to deal with clashes of cultures, whether dealing at a very local or regional level, or at a more expansive, increasingly international, global level. And the same challenges are there. There'll be some differences, of course, in people's behavior and certain norms and expectations of people, but the challenges are still there. And what it requires, in my mind, in arbitration and other forms of alternative dispute resolution, especially mediation, for example, is a very open mind of an arbitrator. And one way of dealing with this, and what I'd expect from any arbitral institution involved, is to take a very proactive approach to support the case management process, to manage expectations of parties and indeed arbitrators, and of course going through a very careful arbitrator appointment exercise with or without the support of an arbitral institution is hugely important to try and avoid some of these problems coming. So of course, if the English language is the language that has to be used in the arbitral tribunal proceedings, then let's make sure that you've got fluent English speaking arbitrators who do understand each other. Perhaps they have worked together before and they have a common understanding and a way of behaving together that would be acceptable and hopefully understandable to the parties. And I hope that all of that careful consideration and working together would lead to a smoother form of arbitral proceeding and hopefully a more satisfactory outcome for the parties in dispute.
I would like to contribute a little bit to what Chris was saying and to the question being put by the audience. I think that international arbitration have successfully created a new language, which include a body language, and also includes the way in which proceedings are conducted. In a way, throughout the world, we have created this language, and we are helping to create this language every day. And definitely, you can see that this new language exists when sometimes, for example, someone that is not familiar with the international arbitration participates in an arbitration hearing. For example, an associate coming from the arbitration practice of a law firm will have a completely different understanding of the rules, and even within the same international dispute settlement mechanism. It happened to me that after leaving my job with the government of Argentina, I practiced in a very large law firm that did different kind of international arbitration. And one of those, one of my first meeting at that law firm was to organize, was a meeting with the purpose to organize a hearing in an exit case. But the partner leading the charge was an ICJ counsel, and he was using different terminology, different organization of proceedings, etc., etc. And we were really talking two different languages. And by the way, I was not the one that was talking the foreign language in that conversation. So I think that we are all learning, and for the audience in Uzbekistan, we are all learning, and I think that we are creating a common language in international arbitration. The best way to learn how it works is to participate in hearings and to have real life experience, and we all will continue to create that common language that we enjoy today.
Thank
Yes,
you.
and I agree. And can I add just a few words just to follow? I agree with my colleague, and arbitration is in the way a balance between these both systems, and try to find the balance and try to understand in a global language of the proceedings. And that is why this, as you mentioned, the harmonization is very important. But still, you should be very careful about the laws, and especially the rules, like IBA rules or Prague rules or US law, and the legal systems, whether English law system or civil law system or US law, is also very crucial. But in arbitration proceedings, yes, you can find yourself in a truly objective, impartial justice systems, and each parties can understand from different coming from different parts of the world. And I think it's a great opportunity, and who is also interested getting in more focusing on this subject to our audience.
Thank you, Serhat. I remember about body language, difference in body language, that, for example, in Bulgarian, to say yes, it's like this, and to say no, it's like this. So it's for me, when I visited Bulgaria, it was an awkward moment, many awkward moments at the beginning. I don't know, do you have something similar with body language in your countries, in your jurisdictions? No?
It's like, maybe I can also add, I mean, it was a not very short time ago, but it was the former prime minister went to US, our Turkish foreign minister, and to US, and the American president was really sitting very flexible, and the Turkish prime minister was very like Asian style sitting, and it was a huge discussion in Turkey that how unrespectful way of dealing with counterparties. I mean, so it may have such kind of approaches, but in the US, it's of course very normal. It's a way of being more friendly, a more relaxed way showing. But in our culture, for example, it was a very long time in the headings in the newspapers. I would like to just note. Thank you.
So to be on the safe side with Turkish lawyers or businessmen, it's always better to be serious No, it's true. It's also like English people usually they're more open and less serious. I mean, they're serious, but when they talk, they can make jokes. And sometimes I know that some people say that even people from former Soviet Union, they are more direct or maybe more cold. So it's always interesting to see, and it's sometimes it takes time to understand that it just in appearance and that it's really like cultural. Now let's switch to the next question. We started already discussing the difference with legal families, and I remember my first year at law school that there are much more than just two families: civil, common law families, Islamic law families. Um, and is there still a clash between civil law and common law? Or maybe from your experience, you have been dealing with other legal systems. Just is there a clash, and if it is, what is it, and how we can deal with it in arbitration? Konstantin, would you like to start?
Thank you, Anna. Yes, I do believe there is still a clash, and of course, a lot depends on the arbitrator and the arbitrators panel, because those arbitrators who do have sufficient international experience, they would know the differences of different legal families, and for them it shouldn't be a problem, and they would counter in the differences in their approach. But for those arbitrators who lack international experience, that might be a real problem. Well, I'll give you an example. There is a different approach to oral evidence in common law legal systems and culture and civil law systems, and indeed the former jurisdictions of the Soviet Union. So in the civil law family, more weight is given to documents and documentary evidence. And in the Russian context, for example, the judges tend to ignore or put very little weight to oral evidence and witness statements. And it's very different in the common law and English law context. And I think that is one of the sort of manifest examples of how legal cultures can be different. And I think that gradually in the international arbitration, the approach is formed that takes best of both cultures. And those arbitrators who are familiar with international ways, they do appreciate the differences. Thank you.
Thank you, Konstantin. Serhat, what do you think?
I may follow Konstantin. I agree. For the witness, not just for cross-examination, I would like to add, but it's the crucial difference, I should say, because we civil lawyers are not very aware, and it's very advantages maybe for the common lawyers because they are very well prepared about cross-examination. And as Konstantin mentioned, we focus on more civil law perspective on documents, and common law more weight to oral testimony, to fact witnesses. And also very interesting differences in common law perspective, you interview and you prepare your witness. I mean, from the civil law perspective, you should think, oh my God, I mean, you tell them not to tell the truth, and maybe it's very dangerous. And that's why it's generally forbidden or very hesitant to make this kind of interaction with the witness. But in common law jurisdiction, it is very common. Even you prepare and you assist writing its testament, and also in advance you prepare your witness statement, and of course at the end cross-examination to find and to try to squeeze the witness to get the truth. And the role is mainly on the counsels the lawyers instead of the judge, the arbitrators. I can say the main differences about the witness between two different legal families. Thank you.
Thank you, Serhat. Chris, what do you think?
Thank you, Anna. Yeah, of course, I'd agree with everything absolutely that's been said in its entirety. I want to take it back a little bit in answer to this question, if I may, in this way, and that is part of my career as a lawyer for 20 years or so now has been working in countries which have tried to bring in the common law, an international sense of common law, often modelled on the so-called English common law. Now it's more global common law, I think, in practice. And we have these debates all the time about the difference between the civil law and the common law. And one of the trickiest obstacles, if you like, to overcome in the early stages of the discussion about whether a country should try and have a common law and a civil law system, or one or the other, or whatever, is whether one is better than the other. And I think that's a very dangerous discussion to have and should be avoided, because I don't think in practice, in my experience, certainly, that it's fair to say that the common law is better than the civil law, or the civil law approach is better than the common law. I think there are positives and unfortunately some negatives of both. And what arbitration provides, I think in practice is a great opportunity for parties and arbitrators to come together, as some of my panel members have already said, to formulate what in practice over years is developing into a very so-called international way of doing things, which might become more of a hybrid of the good approaches from both the civil law and common law. I bring back, again, very quickly in my answer to the importance of getting the arbitrator appointments right as early as possible. If you have parties who are familiar chiefly with the civil law system, then why not try to make sure that you've got arbitrators who also have a thorough understanding of the procedural requirements of a civil law system. Make sure that the applicable standards are relevant and understandable to the parties in the dispute, so that they leave the arbitration feeling that they have had a fair resolution of the dispute because they understood the processes and procedures. They were able to adequately prepare in accordance with the expectations and requirements of the arbitrators. And that way, I feel that we need to place more importance on the expectations of the parties and the ability of the arbitrators then to deliver on that in the interests of fair dispute resolution. If you can do that, and that again places an enormous role, if you like, sometimes on the appointment of arbitrators through an institution or through the parties in agreement, where that's possible, it is very important to emphasize.
Thank you, Chris. We have another question from the audience. Does international commercial arbitration successfully reconcile legal, family, cultural differences, or do practitioners and arbitrators adopt practices that are familiar to them to the detriment of the proceedings? And maybe just it's in the second part of the question. Witness coaching is acceptable in the US, but not in the UK. They highlight that is between civil and common law jurisdictions that there are significant differences. Okay, who would like to take the first question?
I'll have a quick stab, if I may, at the first one, in my humble way. Again, for me, it depends very much on the mindset and the qualifications and experience of the arbitrators that are appointed to the arbitral tribunal. Some arbitrators that I've worked with will take a very holistic, international, wider approach, and they'll be quoting case examples from Switzerland, Saudi Arabia, all throughout the whole world, and bring together their international experience. And other arbitrators will have a more narrow focus on the issues and the evidence before them in the dispute, and will focus very much on one or two jurisdictions. So again, for me, it always comes back to the arbitral appointments.
And if I may, I think that as I mentioned in my previous intervention, I think that international commercial arbitration is doing a fantastic work in reconciling different legal cultures. I think that we can see that, and we can see lawyers and practitioners from different jurisdictions, civil law system, common law system, working together and understanding each other. I would say that we are having this conversation, and I think it's a very valuable one, but at the same time, I think that the clashes of cultures within the international the international arbitration community are the exception, not the rule. There are some cases in which we have a different approach to things, but most of the time we are exactly on the same page.
Thank you, Ignacio.
Maybe I can just add a few, continuing with the evidence. I agree, arbitration try to make a balance. In the US, there's a discovery method, there's a fishing expedition, try to get information to the other party. But in the civil law system, the party representatives are expected to present evidence. And arbitration, like IBA rules, for example, if applies, asks to give a narrow and specific category for request of documents. So instead of all documents of certain types in the US, or just the party presentation in civil, IBA rules says you should narrow and specify the documents. And that's also another example. It tried to find a balance between these two systems, two contrary systems. Thank you.
Thank you, Serhat.
Yeah, I would say that the whole purpose of international arbitration is to reconcile the differences. Because if parties opt for the jurisdiction of national courts, then they're destined to comply with that sort of nation's, that jurisdiction's tradition. Whereas in international arbitration, there is every opportunity to have a more balanced approach. But then I would agree with Chris that a lot depends on the choice of arbitrators and composition of the tribunal. Because if all arbitrators are coming from just one jurisdiction, and if they lack international experience, then there is not that much difference than going to that jurisdiction's court. And in my view and experience, if diversity in the composition of the arbitration tribunal is a key, because if you have a diverse panel of arbitrators, that guarantees a more balanced approach. I'll give another example of clash of cultures in probably in a more philosophical way. In a civil context, the whole purpose of a judge or arbitrator is to deliver justice, is to get the truth out. In a common law tradition, the purpose of an arbitrator or judge is to give parties equal access to justice, to give parties equal opportunity to present their case. And I think that's another fundamental difference in approaches. But as an arbitrator from any family of law, any legal culture, operates internationally, we'll gain experience, and then gradually we take the best from both approaches. So we know different approaches. But for someone who has developed all their career in their own home jurisdiction, it's much more difficult to grasp sort of foreign alien concepts and approaches. Thank you.
Thank you, Konstantin. And it's true that diversity in arbitration, different diversity in arbitration is very important nowadays. We have seen a lot of new initiatives. Maybe other speakers would like also to share their thoughts why it is important to have diverse arbitral tribunals. And also curious how it works on practice when you have, I don't know, is it better to have two civil law arbitrators, one common law arbitrator, or vice versa? So because if you have to, how to balance? Ignacio, would you like to start?
Thank you very much, Anna. That is a fantastic question regarding which I have, of course, my own opinion. And diversity is I think it's a big word, and when we say diversity, we think about different issues. There's one position that is very trendy nowadays, that is to allow women to have a larger role in arbitral tribunals. And what I'm going to say, I say it with utmost respect, which I really hope that women bring a more human approach sometime to cases, and that the kind of things that male do not manage to solve properly are, I mean, at least in my wishes, is that women are going to be able to done a better job, I think, sometimes than the job that we male have done. But I believe in women having a larger role in panels, and you might have read recently that I'm talking about OGEMIT exchanges, that we appointed, my law firm, one of the first all-female tribunals in investment arbitration. I mean, we contributed to the settlement of this, to the setting of this panel. However, I think that this is a perfect venue to make the point that I'm going to make. I think I personally would like, and this is with no offense whatsoever to my colleagues in the panel and all other white men. In a way, I can consider myself a white man. At some point, a professor at the law school where I was attending and I wanted to become a professor said, well, we need someone with diversity, and you are a white male. So maybe I belong to that category. But I think that the point that I want to convey is that either women or men, I think that we need to see more people from the developing world and more people with a different perspective. I think that this is the time of women, that there is an outcry for having more, the presence of more women in arbitration panels, but still the world of international arbitration is composed mainly by white male coming from the developed world. I think that we need to give a chance to the developing world that have a key role, that the companies and states are most of the time parties in international arbitration, and they do not have a voice. This I would like to be my contribution and my perspective today.
Thank you, Ignacio. Brice, what do you have to say about it?
Thank you, Anna. On the topic of diversity, from the outset, like many other international arbitration centers, our arbitration center at the Astana Financial Center in Kazakhstan has its own diversity initiative. And why do we do that? Well, for all the reasons that have just been mentioned by the previous speaker, we want to proactively encourage an inclusive as opposed to an exclusive approach to arbitration, and to make our services as accessible as possible to everyone, regardless of the color of their skin, their sex, their inclinations, or whatever. And for us, that is very important for international access to justice. I wouldn't go as far to say in practice, perhaps, that we want to see more, perhaps, women on panels or more men on panels or whatever. I think you take each arbitration case proceeding one by one on a case-by-case basis, and whatever is deemed to be appropriate for the particular circumstances or needs of that case, I think should be important. So I don't like to look at, well, that person's a man, that person's a woman. I like to not see the sex of the person at all, if possible, and to focus on the expertise of the particular individual when we're considering appointments to arbitral tribunals. One of the other joys of arbitration is of course, that one hopes the parties have an opportunity to decide for themselves, at least in part, if not altogether, if they can't agree together, on who the arbitrators will be. And it's really for them to make that decision for whatever reason that they deem appropriate to meet the requirements of justice, perhaps as they see it from their side, and with the support if necessary of an institution such as ours in Kazakhstan. So we're very positive and trying to promote access to justice for everyone. We do want to see more people involved from all backgrounds. But I think, again, when you're coming to the details of and the specifics of an arbitration proceeding, it's very important to try and work out with the parties or through an institution what is necessary for that case to proceed in the most effective way possible for the parties.
Thank you, Chris. And as we have, sorry, sir, just one small question for Chris, or what's your comment?
Just to add, but after, if you wish your question, I can continue.
Okay, thank you, Serhat. Chris, what is the percentage of lawyers from the former Soviet Union or from Kazakhstan are serving as arbitrators in comparison with lawyers from the common law jurisdictions or from Europe?
So far, we've had, we're into the fourth year, just to give you some context, we're into the fourth year of operations at Arbitration Centre. We've now resolved 625 disputes to finality, and all have been enforced. That aside, not all of those cases have been arbitration. Many have been mediation, and indeed our common law courts as well. But the arbitrators typically so far have come from Kazakhstan or from Russia or from former Soviet Union countries. And that has been what the parties have requested on their particular arbitration disputes. I hope that's helpful. But we do have an arbitrator panel, which is there with more than 40 members from all around the world, with some of the biggest international known names from literally everywhere, the UK, throughout Asia, the US, and so forth. And of course, our region in Eurasia. But that panel is there as an option. So if parties want to have access to those arbitrators, then we help them with that for appointment purposes. They don't have to use those arbitrators. They can appoint absolutely anyone they want. And we do encourage that approach. But so far, the statistics will show that the arbitrators appointed, typically by the parties and sometimes by our IEC chairman, Barbara Doman QC, who has is an appointment authority at our arbitration centre in Kazakhstan. Arbitrators tend to be coming from this region.
Thank you, Chris. Congratulations on this great result. So we can say that your institution give opportunities for arbitrators from developing countries also to serve as arbitrators. Apologies.
Sorry, Anna, can I just very quickly add, if I may, sorry for jumping in again, the topic of women, I want to just emphasize that we with our diversity program, we have actually got many women now on our panel. And we are seeing, I would say, roughly an equal balance of arbitrator appointments between men and women, if that's helpful as a statistic. And that's coming by choice of the parties, more so than from us, encouraging parties to do that.
Kirsten has added a comment that TIAC has several meaningful diversity initiatives, including a working group developing an arbitrator diversity checklist toolkit and a working group developing a roster for tribunal secretaries. For more information, please join us on the session on Friday. So there will be a session on Friday, and if you have a question, if our audience have questions, they can ask them during this panel and get more information on different initiatives of the TIAC. Apologies, Serhat, that I interrupted you.
Of course. I mean, we learn a lot from my colleagues. I mean, and thank you very much for contribution and giving me again the opportunity. I would like to add just now there's a transparency tendency in arbitration institutions, and it makes more diversity, it makes more transparent, and shows how the gender, nation, or color, or other kinds of diversity are applied. Now everybody can see that. It's very important. And we also take it very serious as an EDAC. And I also would like to add, note that in arbitral tribunals, it should also, the tribunal from that kind of perspective, it should be also diversity from looking to the law. I mean, I said, what I mean is it should, especially in investment disputes, it should be able to look from the government perspectives. because mainly I can say many arbitrators maybe tend to apply just for contractual purpose, but there's environmental issues, safety issues, and it's really crucial for if the government can present its case and make them understand to the tribunal. It's very important as a background, or to understand from the state or government practice is also very important, or focus on international public law is also very important from that background. Thank you very much.
Thank you, Serhat. Konstantin, would you like to add something?
Yes, thank you, Anna. Indeed, diversity is a big topic in international arbitration, but I believe more needs to be done on that front. I'll give you an example. London and LCIA remains the forum of choice for many CIS-related disputes, including Kazakhstan, Russia, Uzbekistan, and other jurisdictions. Yet, if we look at the composition of arbitrators panels in LCIA, we'll find that very rarely lawyers from respective jurisdictions are ever acting as arbitrators. And in most instances, the arbitrators will be distinguished English lawyers, Queen's counsels, etc. So, of course, I have absolutely no doubt as to a very high qualification of those arbitrators, and they're very well placed to do their job. Having said that, sometimes, and the practice shows that, these arbitrators may lack understanding of peculiarities of jurisdictions in this part of the world. They may lack appreciation of how business is done. And indeed, the cultural differences that we have spoken about earlier. So in my view, the outcome of these arbitrations would be much more balanced if there would be more arbitrators with roots or experience and training from these jurisdictions. And therefore, I'd like to praise TIAC, Tashkent International Arbitration Center, and indeed, Arbitration Center in Astana. As Chris explained, there are many arbitrators there with backgrounds from the region, and I think that that is very beneficial to the parties and to the outcome of the arbitrators to achieve more balanced outcome if the composition of the arbitration panels is more diverse.
Thank you, Konstantin. And we have a question for Chris. How can one get listed on your panel?
Very quickly, because this isn't about our centre, although I'm grateful for the question, whoever asked it. Just send a letter, please, via our IEC website. The contact email address is there, addressed to the IEC chairman, Barbara Doman QC, or to myself as registrar, and set out why you ought to be a member of the arbitral tribunal, what your qualifications are, with an updated CV. And the critical ingredient for us is to show what arbitrator experience applicants actually have, not that they've just been arbitration counsel. We won't appoint to our panel people who might be very distinguished experienced lawyers, but if they've got no arbitrator practical experience, we won't necessarily consider them for appointment to the panel. So that's what we'll do, and then the chairman will make a decision, and we'll come back in writing to inform the candidate of whether they've been accepted or not.
Thank you, Chris. Clash of cultures. We discuss different parts of this question, but one of the things that becoming more and more apparent is a clash of cultures between generations. I don't know, a couple of years ago, 20 years ago, to practice arbitration, to serve as arbitrator, you need to be to have, like, I don't know, 20, 30 years experience, be qualified in many jurisdictions, to have a PhD. Nowadays, we see that there's different initiatives, and the younger generation of lawyers, they're more eager to serve as arbitrators, even with small experience. and they want to have lead roles in the hearings. So how do you think the situation will evolve between different generations, and maybe some advice to younger generation how to find their place in this huge ocean of arbitration? Serhat, would you like to start?
Thank you very much. I am also academic. That's why I get such kind of questions, how to get involved to the arbitration community as an arbitrator. It is very important, as you mentioned, Anna, to have diversity, and also from that generational aspects. I mean, and we should try to understand each other's and their differences. And what I would like to suggest is the focus on more topic, get more practice, more training. And now there's a more welcoming environment in arbitration community to the newcomers. And as we get more, and it also makes us to use this dispute resolution method more, because people are, especially in developing countries, are more hesitant to, because it's a private dispute resolution method. But more new generations, more arbitrator community gets bigger, I believe that it's also more useful, and then these kind of barriers, maybe invisible barriers, will also break, and it will more widespread usage will apply. Thank you very much.
Thank you, Serhat. Ignacio, what about you?
Thank you very much for the question, and I was going to offer my thoughts. I mean, once I had the opportunity to meet personally Professor Laliv before he passed, and we were having a conversation, and I asked him, well, how do you do to become an arbitrator? And he pointed to his hair. He said, it has to be white. And I think it's a very good summary. I think that people should not try to become arbitrators immediately. My opinion is that there is a lot of things to learn in the arbitration practice. I think what I would suggest is to the younger generations to focus on counsel work first, to become part of a very good practice. I think a lawyer is as good as the experience he or she had. And so my advice also would be not to surrender. There's a lot of competition, but you have to have, if your goal is clear and you would like to participate in the field of international arbitration, you have to keep trying and try to find the best way to achieve your goals. So my advice to younger generations is to apply to good firms, try to get as much experience as counsel as possible. And only when you are seasoned enough, it's your time in order to become an arbitrator. I think that you need not to try to be an arbitrator before you are ready for it.
Thank you, Ignacio. And how, I understand that you spent a couple of years working for the government. How did it help it to build your career? Do you think that it can be maybe also, as you said, to start create a reputable law firm, but is there an alternative?
Your question is a very good one, Anna. I think that sometimes the governments offer a way to take shortcuts in an arbitration career. And there is a very renowned lawyer working for Scan Apps, or now retired, and he said that his legal career, he was originally from Argentina as myself, and he made partner at Scan Apps. And when he was asked about his career, he used to say that that was the consequence of several mistakes in his life. And I think that that describes my career as well. I had a very clear goal that I wanted to practice international arbitration. But in my case, it was the government of Argentina, the one that allowed me to get involved with these large cases. And then after, I don't know, 14 years practicing with the government, I moved to private practice in the United States. But I think that definitely the government can be a great shortcut for a successful career, for example, and just putting the exceptional case of Argentina aside, a very good example, for example, are the lawyers practicing for the government of Canada or the government of the United States that defend the cases. And they come from very well and very well-known law firms. They work for a few years for the government of the United States or for the government of Canada. They acquire a lot of experience, and most of the people that have followed that track ended up being partners in very successful law firms in Europe and the United States. So I think that sometimes a government job can offer the possibility of improve your skills. The good thing about working with governments is that, first of all, you know how they do policy. Second, they offer sometimes access to many more cases than you will be exposed if you are in a traditional partner track.
Thank you, Ignacio. So for our younger audience, or even not for younger, it can be done during your career, just not to spend all the time at a law firm, but to work for the government or an institution. Chris, what is your perspective in this regard?
Thank you, Anna. I'll offer a very quick perspective, if I may. I'm now 41 years old, but I still consider myself to be a young lawyer, although I'm not quite sure that's entirely accurate or true in any shape or form. But like the other panel members, I do various lecturing at universities and so forth. So I'm fortunate to have regular interaction with young legal minds from different countries. It's been an amazing privilege in my career so far. Did I set out from the beginning of graduating law school in the UK to be a registrar of a court in Kazakhstan or an arbitration center? Of course I didn't. Didn't exist. So my advice to young students would be, don't plan too much. You can't plan. And I was doing this as a student 20 or so years ago. I thought I was going to be Lord Chief Justice by the age of 64. It's not going to happen. So it's a waste of time in that regard, planning too far ahead. But what I would suggest is really focus hard as students on getting the best possible training, legal training, and the most varied legal training that you can. The UK offers a very good model for if you can get a training contract as a solicitor in a law firm. You'll be put through a 2 years training contract. Hopefully, if you're on a good firm, you'll get superb access perhaps to different countries, different offices, different ways of thinking, different ethnicities within the legal community, different legal specialities. Likewise, you can go to different governments and get superb experience there and take a flexible approach to career development. But I think the focus on training from day one is extremely important. To think that you can just leave law school and be a world-class arbitrator would be slightly short-sighted and misguided in my view. I agree with the previous speaker to have that experience as a lawyer in any shape, whether it's as an academic, as a professor, or otherwise in the academic world, or as a practitioner. I think it's very, very important to have years of experience development of practical legal problems, scenarios, and finding workable, acceptable, hopefully, solutions, legal solutions to those problems. Very quickly, I'm sure this is very similar with our friends at the Tashkent International Arbitration Center. At our arbitration center, we have a Young Lawyers Initiative, And what we do is we meet regularly with lawyers from this community in Kazakhstan and the region, and we ask for their perspective. We try to open up opportunities. Becoming an arbitrator can be extremely difficult at an international arbitration centre if you haven't got 30 or 40 years experience, or grey, or in some cases no hair. We trying to offer opportunities for young, talented, as we hope they are, lawyers. And so, for example, and this is quite unusual, I think, because I recently attended a Chartered Institute of Arbitrators fellowship program where someone said, no arbitrators will work for free. Well, that's not true in our case, because we have found some superb Russian-speaking barristers, commercial barristers with 10, 15 years practice, sometimes 1 or 2 PhDs as well, in their specific chosen legal field of expertise. And we're offering them arbitrator experience, and they're doing it on a pro bono basis, on some low value, perhaps less sophisticated or less demanding in terms of the law on the facts, arbitration disputes. And by that, they're getting then expertise, experience, and building a portfolio of arbitrator work. And my hope personally is that in years to come, as a part of their arbitrator career development, they will be able to be introduced by the choice of the parties, not just by us appointing them, in arbitration disputes to higher value and more complex, or so-called heavy arbitration disputes. And we're hopefully contributing to the development of the arbitrator community through that initiative. I'm sure it's exactly the same in Tashkent. We're all doing the same things and cooperating together.
Thank you, Chris. Yeah, it's very pleasant to hear about all these initiatives, and that there is always an opportunity. Just we need to stay patient and work hard. Also, there is a comment that UzAW has created an international and diversified team. It has lawyers from different cultures and all continents of the world. The firm develops a system of transferring experience to young practitioners. Ignacio, congratulations, and I'm sure that young lawyers enjoy working with you. And if you, so is there information about this program or this initiative on your website? If you have somebody willing to apply to work at your law firm?
First of all, thank you. Maybe one of my colleagues is the one writing these comments, and thank you to the person that did it. Yes, we are very proud on the diversity of our team. I mean, from the top of my head, we have, of course, practitioners from the United States, but also Ethiopia, Uzbekistan, Peru, Brazil. We really have people from all over the world, and what I can tell you is that the working environment is fantastic. But it is something that I'm sure that you leave also in the law firm that you currently work at. I mean, that great experience of having people and experiences from different parts of the world. I think that's one of the most enjoyable part of our work in international arbitration. We are open to receive young lawyers and to work with them, both advising them and also providing opportunities to work in our firm. We normally have these exchanges with Georgetown University in Washington and with Miami State University in Miami, where our two first, where the headquarters of our firm is located, and now I would suggest the most important office is located as well. But we are open, and to all the people that are listening and participating in this program, please do not hesitate to contact us, and we are going to work with you in order to provide you an opportunity to have a first-hand experience in the arbitration world.
Thank you, Ignacio. The same applies to my law firms. It's true that national arbitration is a great opportunity in comparison with other practices. It's only in arbitration. There are so many foreign practitioners practicing in other jurisdictions. Serhard, what is your perspective on this question?
Thank you very much. I just would like to re-echo the Kristen that remind it's a very good way, and also to Chris that there's a young groups of arbitration institutions like TIAC 45 and other institutions, including Astana, and it's very good start. And also, I would like to say to get into a arbitration arbitrator needs extensive training and practice. It's also maybe a good way of starting from tribunal secretary is also
Yes.
would be a good way. And of course, always try open mind and try to get like GST and other and your law firms who have provide such kind of diversity and training. It's very important to know each part, to have a network and to understand the way of working is very important. Thank you.
Thank you, Serhat. Konstantin?
Thank you, Anna. I agree with colleagues that experience is the key. And by definition, an arbitrator needs to be someone with significant experience, and not just of legal matters, but I would say of life generally, because that person should command certain wisdom and not just a knowledge of law. Yet, I think that there is a problem that until you start getting appointments, you are not considered an arbitrator. So it's much easier to go from 50 appointments to 500 compared to going from 0 to 5. So the real trick is to get the first appointments, and that can be very difficult, and not just for young professionals, young in terms of age, but also for mature professionals, but with lack of relevant arbitrators experience. And as Chris explained, it's hard to get placed on a panel unless you can demonstrate you've acted as an arbitrator before. And therefore, I think that we should praise the initiative of TIAC and other centers to develop a younger generation of practitioners like a TIAC 45 group. I think that is important and instrumental. And maybe as words of hope for the younger generation, there are certain industries like internet-related cryptocurrencies, where the older generation may not have such an advantage because they may not fully grasp all peculiarities of this rapidly developing area, and where younger professionals who have first-hand experience and day-to-day experiences of these new technologies, they may look more authoritative for the parties than a gray hair very respected colleagues. So therefore, I think that in the modern world, there are opportunities for everyone, including the younger ones. Thank you.
Thank you, Konstantin. So one of the advice can be to find a niche and to study, to get acquainted with new technologies, with something that is just appearing on the market. Our next question of the discussion is the difference between you and traditional seat for arbitration, that we know that for many, many years it was like London, Paris, Geneva, Singapore competing to be the leading jurisdiction for the seat of arbitration. Now with different new institutions in different jurisdictions, there are a lot of more competition. And do you think that, and I think you're a little bit biased, but nevertheless, do you think that with time that the arbitration will shift from the European countries to to the east, and that your institution in a couple of years from now will be leading institution with more cases than ICC, for example. Serhat, would you like to start?
Sure, thank you very much, Anna. As you mentioned, when I before getting into before the session, I double checked the seats. Now, as I see, the most selected place of arbitration, mainly the Switzerland, France, US, and UK. But I should also say that their most users are also from the UK, US, and Swiss, and France. When I looked at the ICC statistics, what I see is the Singapore is most preferred seat in Asia, and there is also diversity in also applicable law. What I would like to say is seat is very important, and now it is very great opportunity that you would like to physically see a place and arbitration institutions in your country or office in your country, and know that you can reach them, they can assist you, providing from the arbitrators to experts to hearing facilities. It is very important now. That's why the regional arbitration centers is also very important, and now they are on the rise of their application. But I'm sure the Chris will give information about Astana. But I know that the Singapore, Hong Kong, Dubai is liking rising constantly, because there's a trend. It's a need, and now all these regions, our regions, are also now getting used to the arbitration system, and now we see that now it is a truly international way. Now they are impartial, and the justice is presented, and it is a quick way for international dispute resolutions. So it will be also on the rise, and it will also need, and that's why TIAC is very important, and also Astana is very important, and I also say as a EDAC important, and also other regional institutions are very important. Thank you.
So what about Istanbul and Ankara? How are their perspectives in this regard?
Thank you. We have Istanbul Arbitration Center, which is also on the rise of application. It is, we believe that we can, as I mentioned in my previous speech, we believe that Turkey can be a potential between West and East from cultural perspective, from language, from history, and also a good hub for. It's also very important to have flights and also other kinds of facilities is very important. But I see that all the TIAC is very important for that aspect, because it's also very professionally developing, and I'm also very honored to be also a part of TIAC also. From the Turkey perspective, it's also getting more useful, but the government is also supports from not arbitration, but in Turkey, government supports mediation, and even makes it compulsory for that. So people get used to for alternative dispute resolution method, and it says it works, and now they get more familiar with the system, and it will also helpful for arbitration community. Thank you.
Thank you, Serhat. Chris, please share your view.
Thank you, Anna. I think if anyone was to suggest, and no one today I think is suggesting, that the number of cases or the reliance by parties on the ICC and the like of that type of international arbitration center, maybe London and Singapore, is likely to decline. I think that would be highly unlikely. That said, the emergence of new international arbitration centres in other parts of the world, particularly in the East, so Tashkent, of course, our friends there, and ourselves in Kazakhstan, are already seeing a considerable uptake in work. There's too much, in my view, obsession about case numbers. We always like to rattle off our finger because it's important to show that we are being used and that we're providing a service that hopefully will be or is user-friendly and is acceptable to parties on an increasingly improved basis year on year. But we have many friends that so do the Tashkent Center, so Tashkent Center in China. And a recent call I had with someone in China who revealed that his arbitration center, which he markets as an international arbitration center, has processed 23,000 cases. So there's no way any of us can compete with that in the so-called international world in London or elsewhere, certainly not. So I wouldn't place too much emphasis on case numbers, although it's a useful indicator of the level of trust and confidence that parties have in using your facility. But really it's about the quality of justice. Are the users satisfied with the procedures that they have used? Was there enough flexibility? Were their needs met? Was the centre responsive to their ever-changing business and legal needs and requirements? Did they get the arbitrators that they expected to get? Were they happy with the performance of the arbitrators? How were costs managed? Were there application costs? Was it free? As in the case of our centre in Kazakhstan for the time being. Did you have online digital technology? We do. We use eJustice from the very beginning of a claim all the way through to final disposition, in fact, through to enforcement, through the court of those decisions. How is enforcement managed, if it is at all? And I say at all because I'm aware of some friends at other international arbitration centres who haven't got really any enforcement mechanisms in place for their arbitration awards. So that is an immediate red flag for any party who is opting to use that centre, who has a choice to use it or not. We've developed a robust step-by-step enforcement procedure which does not involve utilising the local court, so it's completely independent of the local court system in Kazakhstan. So far it's been very successful with 100% satisfaction of the interests in dispute being enforced. But I think the ultimate objective really for us all with these increasingly being set up international arbitration centres, building trust and confidence. If we can all do that, then I'm not suggesting for a second that we'll be taking work away from other more established regard international centres, but we'll be developing work of our own. And I think that's what the point I'm making is that is already happening in Tashkent and certainly with ourselves. Tashkent and Astana will not be the only, and Istanbul will not be the only, and indeed are not the only international arbitration centres in this region. There will be many more coming. We speak to them frequently, so we know that's happening. And the objective, I think, will be for us all to cooperate and work together, because in my view, there's more than enough work, and there will be more than enough work for us all to do to meet the requirements of the users.
Anna, something that it would be important to point out, talking about new seats of arbitration versus the traditional seat for arbitration, is the role of the judiciary. Because as we all know, the selection of some seats is exclusively because you can rely on the local judiciary of the seat in order to enforce an arbitral award, enforce an arbitral agreement, apply the international standards according to what is expected. And I just would like to mention that our firm has been involved in developing strongest judiciaries in Latin America. And when I'm saying strongest judiciary, we are speaking about judiciaries that understand what is the role of international arbitration, and that international arbitration is not competing with the work that they should be doing. That sometimes, for example, I remember when I started my career many years ago, well, many years ago, not many years ago, I was afraid sometimes about writing on issues of international arbitration, because at that time it was a topic that it was not very well known, and I felt that my colleagues at the judiciary felt the kind of competition that we were taking their work, and that should not be the case. We do a completely we do a work that can be complemented with each other. So I think that this is another very important issue, especially in the developing world, and in order to create new seats of arbitration, which is to work with the judiciary, and I'm going to use a word that I should not use, but educate the judiciary on what the expectations of the international arbitration community are. And so I think that this is the most important aspect, in my opinion, at the time in which you select the seat of the arbitration, both the traditional seats of arbitration and the newcomers.
Thank you, Ignacio. Unfortunately, we are running out of time. Thank you very much for your input, for your thoughts. It was very interesting to learn different perspectives, and I really hope that next year we will meet all together in Tashkent or maybe in other jurisdictions. I wish you best of luck, and let's keep in touch, and best of luck also to Tiag, and I encourage our audience to attend other sessions. Thank you very much.
Thank you very much.
Thank you.
Thank you, colleagues. Thank you.
Thank you. Bye-bye.
Bye.
Bye-bye.
Bye.